அனைவருக்கும் மாலை வணக்கம். மதுரை வழக்கறிஞர் சங்கத்தின் சார்பாக தொடர்ந்து 7வது செஷன்ஸாக இன்று சிவில் ஜட்ஜ்க்கான பயிற்சி வகுப்புகள் தொடர்ந்து நடைபெற்று வருகிறது. இங்கே தொடர்ந்து நம்மளுடைய சங்கத்திற்கு முதலாவதாக இந்த நிகழ்ச்சியை தொடரும் பொழுது அன்றைய நிர்வாக நீதிபதி மாண்புமிகு நீதியரசர் ஆர் சுப்பிரமணியம் அவர்கள் துவக்கி வைக்க, தொடர்ந்து ஒவ்வொரு வாரமும் திங்கட்கிழமை ஒரு நீதியரசர்கள் இந்த நிகழ்ச்சியை தொடக்கி வைத்து அவர்களுடைய அனுபவங்களையும் மோட்டிவேஷன் ஸ்பீச்சையும் அளித்து வந்தார்கள். இன்று மிகவும் ஒரு அருமையான தருணம். அனைத்து மாணவ நண்பர்களுக்கும் மாணவ செல்வங்களுக்கும் ஒவ்வொரு முறையும் ஒரு நிகழ்ச்சிக்கு ஒரு நீதியரசர் துவக்கி வைத்து செல்வார். ஆனால் இன்று மிகவும் ஒரு தருணம் என்னவென்றால், மாண்புமிகு நீதியரசர் திரு பரத் சக்கரவர்த்தி அவர்களே இன்று வகுப்பை நடத்துவதற்காக ஒத்துக்கொண்டுள்ளார். அவர்களுக்கு எங்களுடைய சங்கத்தின் சார்பாக மனமார்ந்த நன்றியை தெரிவித்து அவரை வருக என்று அன்போடு வரவேற்பதில் மகிழ்ச்சி அடைகிறோம். தொடர்ந்து 7 வாரமாக இந்த நிகழ்வு நடந்து கொண்டிருக்கிறது. 2 சனிக்கிழமையை மட்டும் அந்த ஒரு வாரம் நடந்த வகுப்புகளுக்கான எக்ஸாம் வச்சு, அதில் போன வாரம் கூட மாண்புமிகு நீதியரசர் ஜிஆர் சாமிநாதன் அவர்கள் வந்த பொழுது 3 மாணவர்கள் 1, 2, 3 வரிசைப்படி அந்த மதிப்பெண்ணில் அவர்கள் பரிசை தட்டி சென்றார்கள். மதுரை வழக்கறிஞர் சங்கம் உங்களுக்கு அத்தனை வகையிலும் உறுதுணையாக இருக்கும். நீங்களும் மென்மேலும் தொடர்ந்து இந்த நிகழ்வை கலந்து கொண்டு சிறப்பிக்க இந்த பயிற்சியை நடத்துவதற்கு உறுதுணையாக நீங்களும் ஒத்துழைக்க வேண்டும் என்று கேட்டுக்கொண்டு, இன்றைய தினம் இந்த ஒவ்வொரு வாரமும் நடக்கின்ற நிகழ்ச்சிக்கு ஒவ்வொரு மூத்த வழக்கறிஞர்கள் அந்த வாரத்திற்கு முழுவதுமாக அந்த செலவுகளை ஈடு செய்கின்ற வகையிலே ஒரு ஸ்பான்சர் தொடர்ந்து செய்கிறார்கள். அவ்வண்ணமே மூத்த வழக்கறிஞர் அருளொடி சேகர், மூத்த வழக்கறிஞர் சாமித்துறை, மூத்த வழக்கறிஞர் பாபு ராஜேந்திரன் போன்ற வரிசையில் இன்றைய வாரத்திற்கான நிகழ்ச்சிக்கு அருமை மூத்த வழக்கறிஞர், இந்த வழக்கறிஞர் சங்கத்திற்கு உறுதுணையாக இருந்து செயல்பட்டு வருகின்ற மூத்த வழக்கறிஞர் லஜபதி அவர்கள் வந்திருக்கிறார்கள். அவரையும் வருக என்று வரவேற்பதில் மகிழ்ச்சி அடைத்து, நேரத்தின் தனிமை கருதி அப்படியே நிகழ்ச்சிக்கு செல்லலாம் என்று அன்போடு கேட்டுக்கொண்டு விடைபெறுகிறோம். நன்றி, வணக்கம். எங்கள் அன்பின் வெளிப்பாடாக மாண்புமிகு நீதியரசர் திரு டி பரத் சக்கரவர்த்தி அவர்களுக்கு சங்கத்தின் தலைவர்கள் இந்த பொன்னாடியை போற்றி கௌரவம் செய்கிறார்கள். சங்கத்தின் பொருளாளர் இந்த நினைவு பரிசு புத்தகத்தை மாண்புமிகு நீதியரசுக்கு வழங்கி கௌரவம் செய்கிறார்கள். அதேபோல் இந்த வாரம் நிகழ்ச்சிக்கு உறுதுணையாக இருக்கின்ற மூத்த வழக்கறிஞர் டி லஜபதி ராய் அவர்களுக்கு சங்கத்தினுடைய பொருளாளர் இந்த பொன்னாடியை அணிவித்து கௌரவம் செய்கிறார்கள். சங்கத்தினுடைய உதவி செயலாளர் அருண்குமார் அவர்கள் இந்த புத்தகத்தை வழங்கி அவர்களை கௌரவம் செய்கிறார்கள். நேரத்தின் தன்மை கருதி உங்களுக்கு தடையாக இல்லாமல் வகுப்பை நடத்துவதற்கு உறுதுணையாக வேண்டிக் கொண்டு விடைபெறுகிறேன். நன்றி, வணக்கம்.
அனைவருக்கும் வணக்கம். இந்த வார நிகழ்ச்சியை ஏற்றுக்கொண்டிருக்கிற திரு லஜபதி ராய் மூத்த வழக்கறிஞர் அவர்களுக்கும், மதுரை வழக்கறிஞர் சங்கத்தினுடைய அனைத்து தலைவர் மற்றும் செயலாளர் அனைவருக்கும் என்னுடைய வணக்கத்தையும் நன்றியும் தெரிவித்துக் கொள்கிறேன். முதல்ல என்னை கூப்பிட்டது இதை இனாகிரேட் பண்ணணும்னு சொன்னாங்க இந்த வாரம். ஸோ நம்ம படிக்கலாம். ஏனென்றால் இந்த எக்ஸாமுக்கு மட்டும் இல்லை, ஒருமை தான் கற்ற கல்வி எழுமையும் ஏமாப்புடைத்து. தேர்ஃபோர் இந்த மாலை நேரங்களில் நம்ம இங்கே நம்ம படிக்கிறது இந்த எக்ஸாமுக்கு மட்டும் இல்லை, டெஃபினட்டாக எக்ஸாமுக்கு உதவ போகுது. இல்லைன்னாலும் ஏதாவது ஒரு வகையில் என்றைக்காவது ஒரு நாள் அது நம்மளுக்கு யூஸ்ஃபுல்லாக இருக்கும். அதனால் இருக்கின்ற இந்த மாலை நேரம், இந்த 1 மணி நேரமோ நம்மளால் எவ்வளோ முடியுமோ தெரிந்து கொள்ள முயற்சி பண்ணுவோம். ஸோ வில் கோ ஸ்ட்ரைட் இன் டு த டாபிக். இன்ஃபர்மேஷன் டெக்னாலஜி ஆக்ட் தான் இன்றைக்கு நம்ம பார்க்க போகிற தலைப்பு. சரியா? I don't know how far I'll be relevant from your examination point of view, but என்னை பொறுத்த வரைக்கும் ஒரு சட்டத்தை படிக்கணும்னா அதோட கான்டெக்ஸ்ட் ஃபர்ஸ்ட் படிக்கணும். அப்போது அது எப்போ அமலுக்கு வந்தது, ரெண்டாவது எதற்காக அந்த சட்டம் கொண்டு வரப்பட்டது, எந்த சூழலில் அந்த சட்டம் இயற்றப்பட்டது, அதோட எஃபெக்ட்ஸ் என்னன்னா, ரீசன் தி எத்தர்ன்னு சொல்லுவாங்க, ரீசன் ஃபார் எக்ஸிஸ்டன்ஸ். எவ்ரி பிரின்சிபல் ஆஃப் லா ஹேஸ் இட்ஸ் ஓன் ரீசன் ஃபார் எக்ஸிஸ்டன்ஸ்ன்னு சொல்லுவாங்க. தேர்ஃபோர் அந்த பேசிக்கை நம்ம தெரிந்து நோய் நாடி நோய் முதல் நாடி அது தணிக்கும் வாய் நாடி வாய்ப்பு செயல்ற மாதிரி. ஸோ எந்த ஒரு லீகல் ஒரு சப்ஜெக்ட் இருந்தாலும் அந்த கிளாரிட்டி ஆஃப் தாட் இஸ் வெரி வெரி இம்பார்ட்டன்ட் ஃபார் அஸ், ஸோ தட் யூ அண்டர்ஸ்டாண்ட் இட் பெட்டர் அண்ட் இன் தட் கான்டெக்ஸ்ட், ஸோ தட் வி வில் நாட் மிஸ்அப்ளை ஆர் நம்மள அறியாமல் அந்த கான்டெக்ஸ்ட்டை புரிஞ்சுக்கிட்டோம்னா ஈவன் வென் வி ரீட் த ப்ரொவிஷன்ஸ் வில் ரீட் இட் கரெக்ட்லி. ஸோ தட் இஸ் ஹவ் ஐ அண்டர்ஸ்டாண்ட் திங்ஸ். ஸோ அந்த வகையில் தான் நான் ப்ரிப்பேர் பண்ணியிருக்கேன். If it is slightly out of context for your exam also, don't worry. Like I said, it will be helpful in some other context also. Alright? Good. So, Information Technology Act, it came into force on 17/10/2000. We can go in English and Tamil, bilingual, alright, okay. Then the major amendment came into in the year 2009. There was a major amendment. So therefore it came into force in the year 2000 and there was one major amendment in the year 2009. Okay? So before going to the act, various provisions of the act, why at all? Edhukku Information Technology Act nu onnu vanduchinu pathina, first thing is computer. What do you mean by computer? It can compute any information. இல்லையா? பரத்தோட ஃபோட்டோவாக இருந்தாலும் சரி, இல்லை இங்கே இந்த எழுதிருக்கக்கூடிய எழுத்தாக இருந்தாலும் சரி, எல்லாத்தையும் it can convert into 0 and 1. Convert பண்ணி, store பண்ணி, it can reproduce. This is what we call it as computing. So computerன்ற இந்த ஒரு டிவைஸ் இந்த உலகத்தில் வந்தது. Then it led to the next step is network. So not only this is one device, it can connect to the other device. That was the step 2. So it was called as network. Network nu varumbodhu appo inge irundha anga and information pochu, ange irundha and information inga vandhudu, which led to the next invention called internet. In the நூற்றாண்டினுடைய மிகப்பெரிய போன நூற்றாண்டினுடைய மிகப்பெரிய கண்டுபிடிப்புன்னு சொல்றாங்க இல்லையா, இன்டர்நெட். ஸோ அது ஒரு ஹைவேக்குள்ளே போய் எல்லாம் வர ஆரம்பிச்சிருந்தது இன்ஃபர்மேஷன். ஸோ தீஸ் த்ரீ which led to the what happened is electronic form of information. அதுதான் நான் சொன்னேன், any information can convert it into digital or electronic information, leading to electronic communication, electronic authentication and confirmation. இந்த ரிசல்ட் நம்ம என்ன பண்ணோம், பழைய போஸ்ட் ஆஃபீஸ் வந்து now இமெயிலா மாறிடுச்சு, மீடியா அண்ட் என்டர்டெயின்மெண்ட், எஸ், ஃபைல் ட்ரான்ஸ்ஃபர், ஃபைல் வந்து ஃபிசிக்கலாக ஒருத்தர் வந்து இங்கேருந்து அங்கே கொண்டு போய் கொடுத்தது மாதிரி, யூ கேன் ஜஸ்ட் பை த கிளிக் ஆஃப் த பட்டன் யூ கேன் ட்ரான்ஸ்ஃபர் ஃபைல்ஸ். தென் த மோஸ்ட் இம்பார்ட்டன்ட் திங், த ஆக்ட் அப்போதைக்கு கொண்டு வரும்போது இட் ஹேட் ஒன்லி ட்வின் ஆப்ஜெக்டிவ். இந்த மாதிரி நம்ம வந்து எலக்ட்ரானிக் மீடியாவும் கம்ப்யூட்டரும் இவ்வளோ நம்ம இட் வில் பிகம் த என்டையர் லைஃப்னு கூட அப்போ அவங்க பார்க்கல. ஆக்ட் வரும்பொழுது முக்கியமாக தே கன்சிடர் e-commerce and e-governance தான். These were the two because when our economy was opened for globalization, அப்போ e-commerceன்றது உருவானுச்சு. அதே மாதிரி e-governance அது கொண்டு வரணும். These were the twin main objectives when they brought into force this IT Act. What happened, some of the features of this electronic communication is it has a global reach இல்லையா. இப்போ நம்ம கொடுக்கக்கூடிய இன்ஃபர்மேஷன் நெக்ஸ்ட் செகண்ட் அமெரிக்காவில் இருக்கக்கூடிய சிங்கப்பூரில் இருக்கக்கூடிய நம்மளுடைய ரிலேட்டிவ்ஸோ இல்லை நம்மளுடைய பிஸ்னஸ் பார்ட்னரோ இட் ரீச்சஸ் இமீடியட்லி அண்ட் இட் ரீச்சஸ் ஆல் பர்சன்ஸ் இன் ஆல் ஃபார்ம்ஸ். யூ ஹாவ் வெர்பல் கம்யூனிகேஷன், யூ கேன் ஹாவ் நான் வெர்பல் கம்யூனிகேஷன், ஆடியோ வீடியோ கிளிப்ஸ் எல்லாமே இருக்குது. இட் இஸ் நாட் ஜஸ்ட் ஒரு லெட்டர், ஒரு ரிட்டன் கான்டெக்ஸ்ட் மட்டும் இல்லை. ஸோ இட் வேரிட் இன் டிஃப்ரெண்ட் ஃபார்ம்ஸ். தென் in these things there is nothing called a pre-censorship ன்றது, that concept has gone. Anything you put in your social media, next moment it is visible to everyone. Then persons can improve, morph, add, interpolate, manipulate. You have now and artificial intelligence apps la kuda vandirchu. So today in a 2 seconds you can take my picture, put madam's face on over it, it will look as if she is now conducting the class, or anything can be done. So morphing, manipulation la it appo vandu when they act they saw it as a possibility. Now it is the everyday life, from morning to evening there is morphing, image improvement, it can intrude into your privacy definitely. we all now know ஒரு ஃபோனை யூஸ் பண்ணால் எவ்வளோ நம்மளோட இன்ஃபர்மேஷன் போகுது, எவ்வளோ நம்மளோட ப்ரைவசி is lost. So yesterday also somebody like Supreme Court imposed a condition on the accused. ஒன்றும் இல்லைப்பா, நீ எங்கே போனாலும் you carry the smartphone with your location on or condition was imposed, and somebody wrote an article that is intruding too much into their accused or privacy. There is a limit into which the court can intrude. Therefore it is intruding into their privacy a little bit more அப்படின்னு சொல்லி சொன்னாங்க இல்லையா. Therefore it can intrude into your privacy, it can create immediate panic and social disorder. Yes, we recently saw in that case regarding migrant workers, that accused was arrested, a person from UP, he just created migrant workers are being physically tortured in Tamil Nadu nu solli ennachu, all of them exodus. You saw Tirupur, Coimbatore people fleeing the state, and then that person ultimately arrested. Supreme Court asked him to tender an apology. Recently he was released on bail. We all know about that case. Then free information, unlimited access இல்லையா. We are now in a world called unlimited information. ஒரு இப்போ நம்மளோட yesterday's seniors சொல்லுவாங்க, therefore if they want to know about a particular thing they have to go take the book, and then ஒரு நாள்லாம் உட்காந்து they have to search all the volumes of that SCC, 4 rack இது பண்ணி they have to pick up that book, and then only they have to get the information. Now everything is available for you in a click of the button. It is all in your fingertips already. Okay, the distinguishing features which was there pre-Information Technology Act or pre-internet, pre-computer la enna naka, there is something called a original. Ella document ku there was a original. Today I write a email it to you that please I will be there at 5:30, all the association members and the students be ready. Then which is that original? The one which I typed in my computer, or the one which he received in your computer, or he took a printout of it and gave it all to all of you, whether that is the original? Which one is the original? So the first and foremost, this concept called original is lost. The அந்த பழைய டாக்குமெண்ட்ல உள்ளதுக்கும் இப்போ உள்ளதுக்கும் difference. Then there is any number of statutes. பழைய எல்லா நம்மளுடைய மற்ற லாஸ் எல்லாம் பார்த்தீங்கன்னா it should be in writing. So what do you call writing na? அப்ப என்ன சொல்றீங்க? What do you define as writing? So there were so many documents which are required to be only in writing, orally not permitted. It should be in writing. Orally not permitted. It should be signed. Very important. The document is executed by signing. These were the distinguishing features of the yesteryear's documents. இந்த எலக்ட்ரானிக் டாக்குமெண்ட்ஸ்லாம் வர்றதுக்கு முன்னாடி உள்ள டாக்குமெண்ட்ஸோட இம்பார்ட்டன்ட் ஃபீச்சர்ஸ் இதுதான். தேர் இஸ் சம்திங் கால்ட் ஒரிஜினல், சம்திங் கால்ட் ரைட்டிங், தேர் சம்திங் கால்ட். இப்போ கூட நீங்கள் பார்த்தீங்கன்னா ஆர்டர் 6 Rule 17 or 18 வரும். If there is a books of accounts na, it should be filed at the time of filing of the plaint itself. Original ongoing books of accounts na, original ledger has to be produced. Court will not accept if it is produced on a later point of time because no tampering. But now you are all maintaining your accounts in what? எல்லாம் சாஃப்ட்வேர்ல மெயின்டைன் பண்றாங்க. Where is the question of producing the original book at this time? So that is the time. So it was legible to all and it remained unaltered over a period of time. அந்த ஒரு புக்கோ ஏதோ இருந்தாலும் அது ஆல்ட்ரேஷனே ஆகாம இருந்தது. Third one is you know which is the original and which is the reproduction, which is the copy. And then there was an authentication by the signature, and it was in a form which was acceptable to public authorities, even in a governance point of view, because you know the act has got the twin objective. Public e-governance was one of their most important objective when the act was enacted. So public authorities ஒப்புக்கொள்ளக்கூடிய ஒரு வடிவத்தில் original documents இருந்தது. Therefore it is in these circumstances UNICITRAL a model law was proposed for all the countries to adopt, because now e-commerce, you are sending a mail, the person responds. Therefore some law is to be. எனக்கு இப்போ எங்களோட கிளைண்ட் ஒருத்தங்க என்ன பண்ணாங்க, யூஸ்வலாக அனுப்புறது அவங்க they used to import from China. Okay, they placed an order in the email. Then the Chinese counterpart writes to them, yes, shipping done. அப்போ நடுவில் ஒரு இமெயில் வருது, we have changed our account to this new account, therefore credit the money to this account nu solli. That was a phishing email by which this person sent some 4 crores rupees. Somebody from Nigeria knocked it off. So that is the problem. Therefore there was a lot of problems. Many of the jurisdictions were not even recognizing this as valid contracts. Tomorrow you want to sue the person if he doesn't honor the contract, you have to. Therefore UNICITRAL is the United Nations Commerce and International Trade Organization body. அப்போ அவங்க வந்து ஒரு மாடல் லா கொடுத்தாங்க. Therefore based on that model law, the main purposes were legal recognition of electronic records, firstly, number 1. Number 2, legal acceptance of digital and electronic signatures. Not only records, we have to sign it digitally or electronically. Third one is, there is a new, that's what I said, there is a new gender of crimes. Come with the technology, come with the நம்ம மனிதர்களோட மூளை வந்து ஒரு நல்ல விஷயம் வரும்போது கூடவே அதோட ஒரு கெட்ட விஷயமும் வரா மாதிரி the cyber crimes have come. Therefore how to deal with the cyber crimes? அப்போ இதை எப்படி டீல் பண்றது? Therefore these crimes have to be defined and punishments have to be provided. So for that purpose, then அதுக்கு தேவையான authorities and tribunals have to be established. So these were the 4 main objects of the Information Technology Act. என்னன்னா legal recognition of the electronic records, legal acceptance of the digital and electronic signatures, then punishment for cyber crimes, and establishment of an authority under the act and an appellate tribunal. Okay, it applies to all information, any nature of information whatsoever, because the word information, section 2 we'll just quickly scan through after my presentation. What is information is defined, what is data is defined, what is computer source is defined. You have a lot of definition. Then it applies to all communication devices, computers, computer networks, and computer resource also it applies. Therefore what it doesn't apply, Information Technology Act எதுக்கு அப்ளை ஆகாதுன்னா, those exceptions are mentioned in first schedule to the act. Okay, எதுக்கு அப்ளை ஆகாதுன்னா negotiable instruments. Now அதுலயும் இப்போ further amendment வந்து except a check, now electronic check is available. Check is also a negotiable instrument, but for which now an electronic check is possible. Other, you cannot create a bill of lading or a promissory note in an electronic form, because IT Act doesn't apply to negotiable instruments. Then will, okay, creation of trust, power of attorney, and finally sale or conveyance of the immovable property. These things are mentioned in the first schedule. So tomorrow also the government can notify anything, any particular subject for which the act doesn't apply in Sona. The government has the power to notify it in the first schedule, and it can remove also. Tomorrow it can say even sale of immovable property, the IT Act will be applicable. So the power is given to the government of India to notify, to which the act doesn't apply. Only the exception, everything else the act is applies. General application under section 3 is it applies to the previous thing. I told you, no, all information, all communication devices, computers, computer networks, resource, everything the act is applicable. Exceptions are mentioned in the first schedule. Exceptions என்னன்னு பாத்தீங்கன்னா negotiable instrument, except the check. Then will, creation of trust, power of attorney, sale or conveyance of immovable property. Okay, all movable property sales majority now through online only. Okay, and through e-commerce only. So what is not any conveyance relating to immovable property, then the IT Act is not applicable. Then the second thing it deals with is that about the confidentiality of the உங்களோட நீங்க ஒரு சாஃப்ட்வேர் எழுதுறீங்க, because it is a copyrighted document, nobody can copy, hack or unauthorizedly exploit whatever work you are doing. Therefore, there is something called a confidentiality attached to it. The second thing is called authentication. Who can use it? Who cannot use that information? Who can access your, so ninga ipo bar association ku tomorrow if a website is created, whether you want to make it as a public website or you can create an authenticity, unga member ku mattum login nama kudukurom illaya, that is what is called as authentication. I authenticate you to login so that come inside you can access this in the lessons or the videos la irukku. I don't want to make it public, but for only for my members. Therefore, that authenticity. Then integrity of the information also. Anybody cannot log into anything and write anything, add anything. Wikipedia Mary. Why do we now call Wikipedia as an unreliable source? Because anybody can create a page. BHARATH CHAKRAVARTHY, Romma Nalla Justice, you can just create our Wikipedia page. Nobody can authenticate for the integrity of that information. Though widely which is believed that people should not tell any lie, or normally there is an ethics committee. That is where it lacks, the integrity of the information. Non-repudiation, whenever two persons between the intermediary or the main person, somebody is providing the service, they should not repudiate the contract. இப்போ உங்களை நம்பி நான் வந்து நீங்கள் ஒரு சர்வர் ப்ரொவைட் பண்ணுறீங்க, therefore I am giving all the information to you. So tomorrow you should not make it public, or you should not flout the contract between me and you. So these are the things. Then unauthorized access, disclosure, then the forms of threats also are also there. So somebody is creating a virus. That is what everybody, இப்போ நம்ம e-filing எல்லாத்தையும் கொண்டு வருவோம்னு நம்ம சொல்லும்பொழுது somebody is, எந்த ஒரு பேப்பருமே இல்லாமல் 100% எலக்ட்ரானிக் கோர்ட்டாக நீங்கள் ஆயிட்டீங்கன்னா someday somebody ஏதாவது ஒரு வைரஸை somebody is creating, it destroys the entire information, then what to do? This is the fear which these people are expressing. Therefore, to deal with those forms of threats, அதெல்லாம் deal பண்றது. So these are the areas in which the act operates. Okay? So how does it do this? First and foremost, the important thing is called electronic signatures or digital signatures. Electronic signature is a larger definition. Digital signature is one of its definition. Even today you log into any Supreme Court judgment, digitally signed in varda. Even our now, if you apply for e-copy, nammaloda copy application under e-copy, if you apply, you get it digitally signed. What is the digital signature? Yara paathirkingala the section la. What happens is that under the act provides for licensing several authorities. Appa how they do it na? They create algorithms, which is a computer language which recognizes and by which it creates a unique code for any person. என்னோட கைரேகை எப்படி இந்த உலகத்தில் வேற யாருக்குமே இருக்காதோ அந்த மாதிரி எனக்குன்னு ஒரு கோட் in a computer, which is a safe and secured information which is created, and then எனக்கு அந்த இன்ஃபர்மேஷன் வந்து அந்த டாங்கிளில் ப்ரொவைட் பண்ணுவாங்க. எந்த டாக்குமெண்ட்டை நான் சைன் பண்ணமோ I put it inside, then I authenticate by giving my password, and also my user ID is created, then it comes as digitally signed. Once I digitally signed, நான் அந்த பென் எடுத்து every page அது சைன் பண்ணுறதுக்கு ஈக்குவலாக that is treated. So how that is carried out? Firstly, it provides an unique algorithm like your fingerprint. Secondly, there are certifying authorities. So licensed authorities, நானே ஒரு digital signature create பண்ணிக்க முடியாது. Therefore, under the act, the central government is empowered to frame rules and license some of the authorities. There are some companies and the private players also who have been licensed to give digital signature. So you have to procure from them only. They charge you a fee and then provide digital signature to you. Digital signature along with it comes with a digital certificate கொடுத்துறாங்க. The provided that this mentioned digital signature is the signature of BHARATH CHAKRAVARTHY or signature of so and so, that is called as the digital certificate. Then the electronic records next is that's what I said. The electronic records என்னன்னு சொல்லி the act definition இருக்கு, we'll see. And then it leads to the e-governance and the appellate tribunal. These are the various salient provisions. We'll go one into one. It also empowers the central government to frame general rules for the implementation of the act. The rules involved blocking certifying, licensing, and the business of the appellate tribunal. Then it comes, there are two different distinct compartments of the IT Act. One is the penalty, other one is the offenses. Don't confuse with the penalty and the offenses. There is one set of provisions which are providing penalties, where like Customs Act, you have to go to the adjudicating authority, then the appellate tribunal, which is in the nature of providing compensation to the affected party or a punitive damages to the affected party. So these are called as penalties, and then there is a distinct offenses called penal offenses. That is another chapter. So what are the provisions in Pathina? Section 43 provides for compensation, 43A failure to protect data, then 44 failure to furnish information and returns. Then there is one more separate chapter for the offenses. What are the offenses? Section 66, hacking, not dishonest and intention. For legal, what we call it as opposed to ethical hacking. ஒரு நல்ல விஷயத்துக்கு கவர்மெண்ட் டெமான்ஸ்ட்ரேட் பண்ற போறீங்க, உங்களோட வெப்சைட் இஸ் நாட் கரெக்ட் இந்த பாருங்கன்னு சொன்னீங்கன்னா தட்ஸ் கால்ட் as ethical hacking. So what they say is dishonest and fraudulent hacking is made as an offense. Then section 66A has been struck down by Shreya Singhal judgments. We'll separately deal with that for 2 minutes. That is not now in the book. Now we are having the other offense, section 66B, receiving stolen devices, resources. Both the devices and the resources which is stolen. Then identity theft. என்னோட பேர்ல மெயில் இமெயில் ஆரம்பிக்கிறது இல்லையா, everything, my digital signature you are forging, my parameters you are stealing, identity theft. Then cheating by impersonation, and then violation of privacy. These are the offenses. And 66A you all know, that is the judgment of the Supreme Court in Shreya Singhal's case, where even any inconvenient, intolerable, any information which you upload on the internet was described as an offense. The Supreme Court said, no, it travels beyond the reasonable restriction. It sends a chilling effect on the very freedom of information itself, expression and information itself, and therefore it is draconian solely that section 66A was quashed as unconstitutional. Okay, so this is what generally what happened is that by virtue of second schedule, the Information Technology Act also amended the Indian Evidence Act by introducing section 65B. That's a chinna segment la varala. Before that we will run through the act. Now like I summarize once again why this act, when it came, what are the broad parameters, it contains definitions, then electronic record and electronic signatures, then authorities, certifying authority or adjudicating authority or appellate authority, this is one segment, then penalty, then offenses. Okay, this is the broad view of the, இதுதான் இந்த ஒரு overview மாதிரி, the index itself will give you the overview. So short title and extent, the definitions, then section digital signature and electronic signature. This was primarily the purpose, one of the purposes for which the act came into force. Then e-governance, we will see. E-governance on the provisions la paathukalam. What are the provisions under which the e-governance, which is relating to the e-governance, which are very much relevant to our court also. Like therefore we are relying upon those sections only. So our appellate side rules say that it has to be filed in triplicate, it should be in a paper na. Therefore electronic equivalent is equivalent to that. So therefore when you are saying you should be given a certified copy, duly signed and sealed by the authorities. Therefore these are the provisions which say the electronic equivalent is also is good and it is admissible. So these are the provisions which is relevant to our e-project also. Then again this is again regarding this also very important, the dispatch of electronic records, because physical record la we all have a number of judgments.
ஒரு லெட்டர் நான் உங்களுக்கு அனுப்பிச்சேன்னா when it is delivered, where it is delivered, where the cause of action arose. These were very, very important questions. So when it comes to digital or an electronic communication, so where is that cause of action arising? So that is the provisions. We'll just quickly deal with that. 11, 12 and 3, very, very important in a litigation perspective. In a litigation perspective, quite often than not, place of suing is a problem. Then when the cause of action arose is a problem. Whether the document was served or not is the problem. Because if somebody is dismissed from service, if that order copy is served only, it comes into effect. Under law. Therefore, under the Income Tax Act. So if the reopening is to be done within 30 days from the date of the filing of the thing, then they send a mail that it is reopened. Then when it was reopened, where it was reopened, what is the time? Those are very, very important questions with regard to adjudication and many of our disputes. So that is the chapter number 4 which deals with it. Then securing of electronic records and securing of electronic signature, 14, 15, 16. Like I said, chapter 6 is about regulation and certifying authorities, appointment of a controller, functions of the controller, then applications for license, renewal of license, procedure for grant or rejection of license, suspension, then up to 34 all relating to that certifying authority. Thereafter again electronic signatures, certificates. Previously electronic signatures, finally certificates. This is again the key pair keys, how when more than one person are going to use the authentication. So how do you generate the key pair? Within, like there will be one dominant partner, there will be one Indian partner, there will be a multinational company, there is an Indian company. Those kind of issues are dealing with it. Then as I said, penalties and compensation for adjudication, and finally the offenses. What are the offenses? And then you have the miscellaneous provisions for including enabling the central government to frame rules. So this is the overview of the Information Technology Act, the important definitions. Computer is defined, means any electronic, magnetic, optical or other high speed data processing device. Every one of our mobile phone will come within the definition now. System which performs logical, arithmetic, memory functions by manipulations of electronic, magnetic or optical impulses, and includes all input, output, processing, storage, computer software, communication facilities which are connected or related to the computer in computer system and computer. You can see the definition is very, very wide. And computer network is defined, any satellite, microwave, terrestrial line, wire, wireless, other communication media, everything is a computer network. Computer resource means a computer, computer system, computer network, data, computer database or software. Essentially they are trying to include your server also in the within the definition. So data again is has a very wide definition. Data means a representation of information, knowledge, facts, concepts or instructions which are being prepared or have been prepared in a formalized manner and is intended to be processed and is being processed or has been processed in a computer system or computer network and may be in any form or stored internally in the memory of the computer. Then digital signature is very important, means authentication of any electronic record by a subscriber by means of an electronic method or procedure in accordance with the provisions of section 3. Okay. Then digital signature certificate issued under section 3 of section 35(4). 35(4) those agencies are appointed. Electronic form. So you all, there is a every concept relating to the electronic mode has been defined. Then section 3 is what enables you or any person to authenticate an electronic record by affixing his digital signature. And section 3.2 says the authentication of electronic record shall be affected by the use of an asymmetric crypto system and a hash function which envelop and transform the initial electronic record into another electronic record. Electronic signature, see, electronic signature, there is a definition of digital signature and there is a definition of electronic signature. Electronic signature is like a genus and digital signature is like a species. Electronic signature is a broader definition which includes the digital signature also. So they visualize there may be different forms in the future also. Therefore, electronic signature, they kept the definition little this thing in a larger perspective. They say, notwithstanding anything contained in section 3 but subject to the provisions of subsection 2, a subscriber may authenticate any electronic record by such electronic signature or electronic authentication technique which is considered reliable and may be specified in second schedule, and for this purpose electronic signature or electronic authentication technique shall be considered reliable if the signature criteria and data so and so which are authenticated and no other person can use it, then any signature criterion or data or authenticated data at the time of signing or the control of this, it must be in the controller of the control of the signatory. That is very important. Then it should fulfill the other conditions which are prescribed under the rules. Then comes, see, these are the provisions relating to the electronic governance. What it says, where any law provides that information or any matter shall be in writing or in typewritten or in printed form, then notwithstanding anything contained in such law, such requirement shall be deemed to have been satisfied if the information or the matter is rendered or made available in electronic form, accessible so as to be usable for a subsequent reference. This is a very important provision. Wherever any act, endha sattathiliyum endha rule anything should be required in writing, typewriting or in printed irundha, adoda digital equivalent or an electronic equivalent shall be treated as equal. This is the most important enabling provision. Similarly, section 5, where any law provides that information or any other matter shall be authenticated by affixing the signature, or any document shall be signed or bear the signature of any person, then again, ange non-obstante clause, notwithstanding anything contained in any such law, such requirement shall be deemed to have been satisfied if the information or the matter is authenticated by means of electronic signature affixed in such manner as may be prescribed by the central government. This is the next important provision under the Information Technology Act, because you will need, starting from the Indian Evidence Act and in several other statutes, there will be say it should be in writing, it should be signed. So there will be in so many laws which will require that the thing should be signed. Therefore, section 5 is the equivalent which says that electronic or digital signature, if you sign also, it is enough. Section 6 enables this use of electronic records also. So that is why we say the e-filing, all our e-court bundle are all going to come within this purview only. Where any law provides for the filing of any form, application or any other document with any office, authority, body or agency owned or controlled by the appropriate government in particular manner, the issue or grant or any license, permit, sanction or approval by whatever name called in a particular manner, the receipt or payment of money in a particular manner. That is how we now pay court fee online. So then, notwithstanding anything contained in any other law for the time being in force, such requirement shall be deemed to have been satisfied if such filing, issue, grant, receipt or payment, as the case may be, is effected by means of electronic form as may be prescribed by the appropriate government. நம்மளோட e-filing எல்லாமே even in the government இருக்கட்டும், கோர்ட்டுக்கா இருக்கட்டும், if you are filing, then 6A is the answer. Similarly, anything government grants you, இப்போ now patta, everything is granted online, இல்லைங்களா? All in electronic forms only. So all that comes under section 6B. And then நம்ம pay பண்ற court fee, stamp duty, எல்லாமே everything is covered under section 6C. See, these are the provisions which basically enable e-transactions. Very important are 4, 5, 6. So the government is given the power to frame the rules. Then section 6A creates a service provider. When we comes to court fee, we go into the website of the company which provides our service and then purchase court fee. So those are called as service providers. Yes. Section 7 again is important. Where any law provides that documents, records or information which shall be retained for a specific period, then that requirement shall be deemed to have been satisfied if such documents, records or information retained in electronic form, if the information contained remains accessible so as to be usable for subsequent reference. So இது எல்லாத்துலயுமே பாத்தீங்கன்னா that is very very important. It should be accessible and then it should be usable for a subsequent reference. Electronic record is retained in the format in which it was originally generated, sent or received in a format which can be demonstrated or represent accurately in the form of information originally generated, sent or received. Then the details which facilitate the identification of the origin, destination, date and time, dispatch or receipt of such electronic record are available in the electronic record. We are a court of record. Nammala High Court is a court of record, on account of which we can, number rules pathina, there is a, every case there is a part A and then part B record. Part A record since we are a court of record, we are supposed to maintain that. That is how neenga pathina number starting from the High Court, even the full court meetings, the administrative files, everything is maintained in original. And part A record of our every case bundle is maintained in original. As a result of which now we don't have space at all in the High Court. Half of the High Court is therefore now by virtue of this section 7A only, we are thinking of, we are digitizing, the process is started. You all know the third floor of that wing and the mediation center mala. Now it is being digitized. All our, we call it as legacy record digitization. Therefore, in the Madras High Court also, Angiyo, we are Madrasli, we are digitizing. Now we are going to alter because of enablement under section 7A. 7A says any information access. 7.1 says that any law provides that documents information shall be retained. That is how the digitization, all our erstwhile records, this is the provision which enables the government, even under the government, any patta, chitta, adangal, the revenue records, everything is digitized. All our yesteryear records is digitized and stored also. That is equivalent to the original. Tomorrow, if the original is not available also, then section 7.1 says that information is retained for a specific period, then that requirement shall be deemed to have been satisfied. Such documents are retained in electronic form itself. So that is the provision which enables e-governance, many of the government institutions, judiciary, etc. Then the audit of the documents maintained in the electronic form, it provides an audit also. What are the securities it has to show? The NIC and there are the authorities which they provide. For example, nammaloda court documents, they have maintained, there must be at least 2 servers. One server should be in a non-seismic zone. So Chennai is prone to seismic, earthquake suddenly if everything goes inside the sea, everything is destroyed. Therefore, there must be one backup in Madurai in a non-seismic zone. For Delhi High Court records backup Madurai la vekirom. Number High Court apart from being in the cloud, it is served in 2 different places. There are some places around Bangalore, there are some places which are not at all seismic prone. There are some places which are more prone to seismic zone. Adallang they have classified and they are saying storing of this information in non-seismic zone also. So that is where this audit of documents maintained in the electronic form. Whether it is prone to any breach, whether it is properly stored, idella audit la we are seeing. Then public rules, regulations are also in electronic form is now made it in mandatory. That is how e-gazette of the government of India, e-gazette of the state of Tamil Nadu. Everything, now any law, now it is mandatory. In the new law vandalum, it is now published in the e-gazette also. That is what it said. Wherever gazette is to be published, all this publication now it is made mandatory to be in the electronic form also. So the discretion is given to the particular department. Like you cannot insist that I will only give in electronic form. They have to switch over voluntarily. That is what section 9 says. Then section 10 is the section by which the central government is given the power to make the rules. Then it comes the attribution, acknowledgement of by a receipt. Very, very important is the time and place of dispatch. Now what they say is, from my personal computer, the moment, the split of the second it reaches the network outside my personal computer, it is deemed to be dispatched. It is deemed to be served on it. Therefore, now the place of serving, maybe when I send a mail in Madurai, from Madurai to Chennai, where originator system to the common system, where it happens in Madurai itself. Therefore, the place of serving is in Madurai itself. So that is the difference between an ordinary document and an electronic document. That's section 13 is very important. Save as otherwise agreed to between the originator and the addressee. The dispatch of an electronic record occurs when it enters the computer resource outside the control of the originator. The moment I click upload, mail நீங்க எப்ப திறந்து படிக்கிறீங்கன்றதெல்லாம் it is not the service. Or உங்களோட system down, நான் மணிப்பூர்ல இருக்கேன், the internet itself is blocked for 2 weeks. Therefore it cannot be deemed to be served on me ன்னு சொல்ல முடியாது. The point is that the moment my originator system na என்னோட system க்கு IP address கொடுத்திருக்காங்க. So 061, you have an unique number for every system. அந்த அதோட அந்த எல்லையை தாண்டி when it enters the internet itself, the split second it is deemed to be served and dispatched unless you have a contrary agreement with that person. Secondly, save as otherwise agreed between the originator and the addressee. The time of receipt of an electronic record shall be determined as follows. The addressee has a designated computer source for the purpose of receiving the electronic records. The receipt occurs the time when the electronic record enters the designated computer or the resource. If the electronic record is sent to a computer resource of the addressee that is not the designated computer resource, the receipt occurs at the time when the electronic record is retrieved by the addressee. Dispatch is one, receipt is another thing. Then the see, the place of business is also given. Section 3 is also very important. Subsection 3. Save as otherwise agreed between the originator and the addressee, an electronic record is deemed to be dispatched at the place where the originator has its place of business. That's what I told you. When I am sending you a mail, it is dispatched in Madurai. You may be receiving it in Delhi, but the place of dispatch is in Madurai only. That is what the difference between an electronic record. Then the provisions, once again I will read the subsection 3 for you. Save as otherwise agreed to between the originator and the addressee. An electronic record is deemed to have been dispatched at the place where the originator has its place of business and is deemed to be received at the place where the addressee has its place of business. Okay? Then comes the next chapter 5 is about the security of the electronic record. Where any security procedure has been applied to an electronic record, the specific point of time such shall be deemed to secure from such point from the time of verification. These are some of the technical details of the act. from the time and point of which which they call it authentic record, verified record, everything is deemed to be. Therefore, like even if you go and see our digitization records, like if you can see, there will be a particular point where we conduct the second authorization and then we say secured. Thereafter nobody can tamper. இப்போ ஒரு டாக்குமெண்ட் அவங்க ஸ்கேன் பண்ணும்போது நீங்க பாத்தீங்கன்னா அந்த ப்ரொசீஜர் தெரியும். Before that the vendor and our staff will improve that page, everything. But once that secured and the security zone க்கு அது போயாச்சுனா, thereafter nobody can tamper with it record. So security procedures and practices, central government is given power to give. Then regulation, these chapter 6 is by, there is a controller who is the authority. Then what are the functions of the controller? Exercising supervisions, then certifying public keys, laying down the standards to be maintained, specifying the qualifications of the employees of the certifying authorities, things like that. Again is power to recognize the foreign certifying authorities. We have to recognize the foreign certifying authorities also, because international trade and commerce are happening. Then issue of licenses, this is very important, section 21. How a license, who have to apply for license, then how a license have to be renewed. All this entire chapter is for the licensing authorities who provide. We have to purchase a digital signature, you have to purchase an electronic signature, they have to apply for a license and get licensing. There are 4 or 5 agencies who are at present authorized to supply digital signature. So Ningle, you can purchase an electronic signature, a digital signature for yourself, for your personal use, which you can use it to authorize all your emails, all your communications. So you have to purchase from one of those authorities. They have to be certified and they have to be licensed by the central government. This chapter deals with the entire procedure, how to notify, how to apply, how to renew their license. Similarly, 35B is also the certifying authority who certifies finally and gives the this thing. This is like, there is a previous section 9 and then it is complemented by section 35. Any person may make an application to the certifying authority for the issue of electronic signature certificate in such form as may be prescribed by the central government. One is digital signature. The second thing is called as an electronic signature certificate. As I told you, it may be in other modes also. Therefore, you can get an authentication done and certification done under section 35 if you are going to use other modes also. Similarly, representations upon a certifying authority while issuing shall certify that it has complied with the provisions of the Act. So what are the things the certificate should have? Those things are functions. Then there is provision to suspend, revocation whenever there is any misdemeanor or when the occasion arises. Notice of suspension, revocation, because once you give a license you have to revoke also if there is a misuse, if they are not giving properly, if there is security is breached, if the unique identity is not there, so the government can refuse. Similarly, the duties of the subscribers are also mentioned. You cannot tomorrow may render the very purpose nugatory by your own act. Therefore, duties of the subscribers. When you accept a digital signature certificate, so what are the powers? There is also a repository which is created so to grant an authenticity. Then private key and its control. A private key is given to you. So how you should exercise control? You should not publish, you should not give, like we had this private key, there are several cases you can see in the sub-registrar office itself where those stamps have been used second time, third time, where the sub-registrars, they have divulged their keys to their assistants and other persons also. So in the evening this fellow will use the key and again revalidate all those stamps. That was a major scam which was going on in many of the sub-registrars office. We witnessed in Madurai, we witnessed in Chennai, there were a lot of anticipatory bail applications, where now the stamp duty is paid by way of an electronic certificate. That certificate has to be effaced and that money has to be pulled into the government account. These fellows use this key, private key, and again cancelled that defacing so that the document was made valid, and then these brokers and other persons use this electronic document for registering other documents also. The crores and crores of rupees. பாருங்க நம்ம இன்னும் அடாப்ட் பண்றதுக்கு முன்னாடி these fellows are very quick to misuse those provisions. Then, as I said, 43 is the penalty or compensation. If any person without the permission of the owner or any other person who is in charge of the computer system or network, these are the unethical hacking, downloading, introducing or caused to be introduced any computer contaminant, even including those viruses which they are called. So damage caused, disruption, everything, so destroyed, sealing the information, is liable to pay damages by way of compensation to the person so affected. So you can, any person affected, any person steals your information, tampers with or does any harm to you, you can claim compensation. So each of those, what is meant by computer contaminant, what is meant by virus, what is meant by source code, everything is also defined. Similarly, compensation or failure to protect data. I entrust my data to a cloud today. There are person who offers, who keep this data in a server. We pay and purchase a bandwidth with the agreement that he will keep our information secure. So if they fail to protect that this thing, those are the regulators which they call service providers and penalty. So the power to adjudicate is given to the adjudicating authority, and then the appeal to the appellate tribunal. The telecom appellate tribunal is the tribunal for 4 or 5 acts we all know. This act, TRI Act, and then the Information Technology Act. All now it is in New Delhi. There is an additional bench also. Regional benches are also there for the appellate tribunals. The procedure in which the appeals, like your any other DRT or other appeals, only the normal same procedure which is given. Powers of the appellate tribunal. Then limitation is provided. Civil court jurisdiction is ousted. Then there is an appeal provision which lies to the High Court. Then there is compounding. Both parties, if they want to compound in respect of the compensation, there is provision for compounding. And then how to recover. If the a certificate of recovery certificate is issued, and then it should be recovered as an arrears of land revenue, like any other enactment, it can be recovered. Then comes the offenses. What are the offenses and the punishment? Tampering of computer source code, and then section 6 other offenses relating to the computer related offenses. 66A is for sending offensive messages through communication, which is now declared as unconstitutional by Shreya Singhal. Section 66A is no more. 66B is dishonestly receiving stolen computer resource or computer device. Section 66C is identity theft. 60D is punishment for cheating by personation by using computer resource. Then 66E is violation of privacy. This is where they capturing our images without our authorization and then transmitting, all comes within section 66E only. F is cyber terrorism, where you destroy a particular network, you destroy a governmental network. All these are termed as cyber terrorism. Then obscene material under section 67. Most of our reported cases are under section 67. 67A, material containing sexually explicit materials. Then especially when it 67B is child pornography and other things. 67B. Then when we fail to preserve the information by the, that is what the intermediaries, those are the persons who provide you services, these cloud owners, those companies. If they fail, that is also an offense. These are the offenses. Then comes the general directions and the things. I think this is the broad overview of the act as such. So now I think time might just end. We have some time. All right. We'll quickly just see section 65B. I'll just, you all know, because that will be very more important for your exam point of view. Therefore, we'll touch upon it. So, the Information Technology Act, by the provisions contained under second schedule, it also brought in amendment to various other enactments. One such very important thing is section 65B of the Indian Evidence Act. So, how to mark these documents? How will the court deal with this? Because of e-filing, e-transfer, that I said, how a document has to be approved is contained in section 65A and section 65B. Section 65A says, notwithstanding anything contained in the Indian Evidence Act, any electronic document has to be provided by producing a, what we call it as certificate under section, in the manner as provided under section 65B of the Indian Evidence Act. Then section 65B said that any electronic record, you need a certificate. When certificate is needed, what are the contents of the certificate? Who has to certify? What is to be certified is description of the electronic document. I, BHARATH CHAKRAVARTHY, I am the owner of the personal computer, having domain and access to the computer. So, you have to describe the electronic equipment from which you got the document. If it is a personal computer, you have to say it is a so and so personal computer of IP address so and so. So, any IP address you can know, there is a provision, you can enter it as C colon. If you ask, it will give you the unique number, which is called the IP address. So, description of the electronic document. Then what is the document which I downloaded? It is an email sent in my electronic mail ID so and so to so and so mail ID. Then description of the certifier. I so and so, my name and address should be there. Or if I am a particular authority designated a statutory authority, that should be there. Then you have to certify that it is a true copy. I downloaded, I have not done anything with that. It is the same copy as which is stored in the electronic form in the particular network. And then if in special cases there may be additional information which may be necessary, like in case of investigation where the authority say, as by way of an expert, the court authorized me to crack this particular hard disk, and therefore I did it and I retrieved the information. Those are the things. This has to be who can certify? There are two things. One, all your personal matters, any person who downloaded, who uses the concerned email, who uses the concerned computer, he has to self-certify. If I am the petitioner in a case, if I send mail to the other side, then I have to certify that by using my personal computer bearing IP address so and so, I sent this email to so and so, or I uploaded this document, I uploaded these particulars. Then, or secondly, the person responsible for the management of the affairs. If you are, say for example, in a criminal investigation, police is containing the call data records. For example, one accused spoke to the other accused through a cell phone. Appo electronically we are trying to prove. The paranga offense nadakradhukku 5 minutes munadi A1 has contacted. Appo enna police prove pandranga? There is a cell phone which is used by A, the accused. There is another cell phone which is used by B, the other accused. Appo identity of that. Then secondly, there is one call which is gone from this cell phone to other. The tower details. Paranga, in the accused who actually cut the person with an arwal, his tower, our cell phone tower, it shows near the particular area, Matuthavani area, on the road kitta ulla tower la it is showing. So the tower details. Then the third thing, the time and the other details stored in the computer. So who is the person who is in the management of these affairs? That particular service provider order and the technical person who is empowered. Authority whom can give that. Those are the person, those persons has to only, correct? Therefore, whenever a statutory authority who is in the management of the affairs, he has to certify. Otherwise, the person responsible for the device, when I download something from my computer or my cell phone, I can myself certify. Or if you are not doing it, court is authorizing the investigating officer to crack open the mobile phone and then get the information. He is going to say, I am authorized by the court to crack open. I am the expert in the field, therefore I have done it. Then what happens? There is a series of judgments of the Honorable Supreme Court of India in this regard. Okay, the first judgment was the Navjot Sandhu. So this was an appeal against the conviction following the parliamentary attack. When the CCTV records were produced before the Supreme Court, it was argued that unfortunately in that case 65B certificate was not produced. Therefore, those accused argued that this evidence were not admissible in evidence. This was the first judgment. The Supreme Court said that it concluded that by cross-examining the competent witness, the section is substantially satisfied. Therefore, even in the absence of section 65B, these materials can be looked into. This is the first judgment. Second judgment is P.V. Anwar. P.V. Anwar overruled Sandhu. Sandhu is the first judgment. P.V. Anwarla they said no. Section 65B is a mandate. It says non-obstante clause. Therefore, they held that the previous judgment in Navjot Sandhu is not good law. They specifically overruled this thing and they said it is mandatory. It cannot be dispensed with. No court can look in the look in an electronic record on evidence. They said the court held that it's a non-obstante clause would override the general law on secondary evidence under section 63 and 65 of the Evidence Act, and so on, so on, no application. Therefore, they said it is mandatory. Then came the Shafi Muhammad was the third judgment. Supreme Court held that the requirement of certificate to make an so where they said wherever the interest of justifies so justifies, they sought to include an exception clause that sometimes it is not possible to get the electronic evidence from the concerned authority. Sometimes whether it is secondary evidence or secondary evidence of a secondary evidence or even a copy of a copy of the copy, therefore that itself is not clear. Therefore, the Supreme Court said there may be some circumstances where we can give exceptions to the requirement under section 65B. This is the third judgment. But ultimately, that is why it was referred to a three-judge bench in Arjun Pandit Rao. This is the final judgment which holds the field by Arjun Pandit Rao. Now it has been held that it is mandatory. In no circumstances. They said you can, even at the time of arguments, if the court feels that 65B, it is always a curable defect. You again reopen, get the document done, get the certification done, and do it. But you can, in no circumstances, you can say that all right, in this circumstance, I am not able to do that. They have also granted a procedure where that particular authority is not giving. A detailed directions are given. If that authority is not available, then a request should be made through the court, and then the court should issue a positive directive from which, if not that particular authority, the court should draw up a certificate drawn by the court itself and then admit the evidence. So the final Arjun Pandit Rao is again now followed by the later three judgments also. I will give you the citations. Okay, all right. I'll give you the citations, don't worry. I'll reach it to you here. So it is followed up till date. So Arjun Pandit Rao is a judgment which holds. ஒரு புக்கும் அது கூட ஒரு 3 பேப்பரும் வச்சு கொடுத்தேன். இதோட எடுத்துட்டு வந்தாங்க. All right. So those are the three judgments. So this is all about, so section 65B, you have to know what is the contents of the certificate, who has to certify, when it is required, and whether or not it is dispensable or not. That is the questions. So Arjun Pandit Rao, you all have to go through those this thing. So what I can do is, idu ellame I have put it in a folder. I'll just try to Arjun Pandit Rao, everything is there. I think you all can read it yourself. It's a detailed judgment. Once you have to read Arjun Pandit Rao, then only you will know what. And I have also mentioned 65B is a little outdated. 2000 la நம்ம act கொண்டு வரும்போது கொண்டு வந்த ஃபார்ம்ல வந்தது. Therefore it has to be reviewed. This has been quoted in the latest Yuvraj judgment also by Justice M.S. Ramesh and Anand Venkatesh also. So there is a review committee which is constituted for this thing also. Say maybe it will come in a different form also. But as on date, the Arjun Pandit Rao deals with the form. Eppadi kudukano, when what is the procedure, even if the authority is available, how you have to give the request to the court, and how the court has to mark the document is all contained in this. So I will copy these judgments, and also even the Shreya Singhal also you can just have a cursory look, because from an exam point of view, because as a practical point of view, as a lawyer, I can say 66A is gone from my mind, and the Supreme Court has held it unconstitutional. But from an exam point of view, they'll again ask under what parameters the Supreme Court struck down the law under Shreya Singhal. Therefore, you always go through this Shreya Singhal. You can, from your examination point of view, how they held that it is unconstitutional. They defined there are three elements: discussion, disclosure, and invasion. They said even if you allow this offense to be in the book, even any discussion and disclosure would also. And they said annoyance, yes, if I give a version which is not acceptable to you, then it will annoy you only. If I am a non-believer, you are a believer. When I say that there is no God, then it will annoy you only. That is the thing which they took into account. It will. That is why they say ultimately concluded by saying that it will have a chilling effect on the very freedom of speech and expression itself, and then they quashed it. So it is desirable that you all go through this Shreya Singhal judgment also. Anything else? Anything you want to ask me, you can ask me. Yes. Okay. அதுதான் இப்போ நான் அதாவது என்ன ஆச்சுனாக்கா அது ஓகே I'll repeat. நீங்க இந்த யூடியூப் வீடியோலே போய் பாத்துங்க, கொஞ்சம் டீடைல்டா சொல்லிருப்பேன். லைக் உட்காருங்க. The point is why this act ன்றத நாங்க படிச்சோம். The point is e-governance. When India opened its economy to the globalization, because of e-commerce வந்தது, e-governance வந்தது. அப்போ இந்த கம்ப்யூட்டர் நெட்வொர்க்ஸ், இந்த இன்டர்நெட் இதெல்லாம் வரும்போது it necessitated, when we started using the electronic documents எல்லாம் இது பண்ணும்போது it necessitated, therefore United Nations Authority on Commerce and International Tradeல ஒரு மாடல் லா அவங்க ஃபார்முலேட் பண்ணி எல்லா கண்ட்ரீஸையும் they asked them to consider accepting a similar law. Therefore, considering the necessity and the United Nations model law, we enacted this document. Why எதற்காக இந்த law வந்ததுன்னு தான் நான் first கொஞ்சம் டீல் பண்ண. I think therefore you can go through this lecture also from the beginning, so that will be useful for you. Yes, any law you have a power. Appo you have to trace out the particular entry of the union government to enact this law. Constitution is a source. Law is enacted for a particular purpose. The legislature feels the need for a particular purpose, they enact a document, enact a law. For enacting that, they should have the power. Under list 1, the Union of India has powers under which only the law has been enacted. எதற்காக இந்த law enact பண்ண காரணங்கள் e-commerce, e-governance, electronic documents, computerization, internet இதெல்லாம் வந்ததால தேவை ஏற்பட்டுச்சு. அந்த தேவைக்காக அரசியலமைப்பு சட்டத்தில் உள்ள பவரை யூஸ் பண்ணி இந்த law enact பண்ண சொல்லுச்சு. இதை enact பண்றதுக்கு இந்த யூனிசிட்ராலோட மாடல் லா வாஸ் த பேஸ். உங்களோட क्वेश्चन ஆன்சர் பண்ணனா சொல்லுங்க, நீங்க என்ன கேட்க வந்தது சொல்லுங்க. Okay. Very good. Okay, அதான் therefore the need was felt in a Supreme Court judgment இல்லையா? இப்போ நம்ம வந்து காலங்கள் மாறி வருது. அப்போ எல்லா ஒர்க் பிளேஸ்லயும் ஆண்களும் பெண்களும் சேர்ந்து ஒர்க் பண்ணும் பொழுது there is need to be a harassment, அதாவது வேண்டும்னே செய்யறவங்களும் இருக்காங்க, நம்மள அறியாம ஹராஸ் பண்றவங்களும் இருக்காங்க. We have given a judgment recently in the சென்னை மெட்ரோ ரயில் ஒரு ஆர்பிட்ரேஷன் கேஸ்ல. அப்போ அதுல என்ன கொஸ்டின் வந்துச்சுன்னா, இவங்க என்ன பண்றாங்க, ஆர்பிட்ரேட்டர்ஸ் வந்து தே அனலைஸ்ட், அவங்க வந்து இப்போ ஒரு டேட்டாவும் இந்த மாதிரி எலக்ட்ரானிக்கலா ஸ்டோர் பண்றாங்க. சென்னை மெட்ரோ ரயில் ஒரு ப்ராஜெக்ட் அவங்க இது பண்ணும்போது என்ன ஆகுதுன்னா, எவ்ரி ஈவெண்ட்னு சொல்றாங்க. அப்போ ஒரு நிகழ்வு நடக்குதுன்னா என்னன்னாக்கா, இதுலேருந்து இவ்வளவு தூரம் டனலிங் இஸ் அன் ஈவெண்ட். அந்த டனலிங்லையும் அந்த போரிங் இஸ் அ சப் ஈவெண்ட், அந்த பிளாஸ்டரிங் இஸ் அ சப் ஈவெண்ட், and then fixing the rails and the sub event, and the signal இதெல்லாம் பொறுத்துறது. இது அந்த மாதிரி everything is connected as a sub event and event இருக்கு. அப்போ ஒன்னு ஒரு டேட்ல அது அவங்க வந்து இட் இஸ் a time bound contractன்றாங்க. இன்ஃபேக்ட் அதை நம்ம புரிஞ்சுக்கணும்னாலே we need to be an engineer. அப்போ அதுல 3 டொமைன் எக்ஸ்பர்ட் ஆர்பிட்ரேட்டர்ஸ் அதுல அப்பாயிண்ட் பண்ணாங்க. அவங்க என்ன பண்ணாங்க, இந்த கீலாம் இவங்க கீன் பண்றாங்க இல்லையா அவங்களோட சாஃப்ட்வேர் ரிசோர்ஸ்ல, அதை எடுத்து அனலைஸ் பண்ணி they gave the verdict. So the argument of the government of India was, no, they have created a document. Those are the document. The judge itself is creating a document. Therefore set aside the award னு தான் சொன்னாங்க. அதுக்கு நாங்க என்ன ஆன்சர் பண்ணிருந்தோம்னா, நீங்க சொன்னதுதான், knowledge and wisdom is different, document is different. அவருடைய சுய அறிவை எதுக்காக நம்ம டொமைன் எக்ஸ்பர்ட் ஆர்பிட்ரேட்டரை போடுறோம்? ஜட்ஜ் எதுக்கு லா படிச்சுட்டு வராரு? அந்த லாவை அப்ளை பண்ணி அவர் அதுல ஒரு அவுட்புட் பண்றாரு. அப்போ அந்த மாதிரி அந்த சுய அறிவார்ந்து அவருடைய அறிவினால அவர் அதை அனலைஸ் பண்ணி எடுத்து வர்றது இஸ் நாட் அ டாக்குமெண்ட், இஸ் நாட் அ டேட்டா. அதுதான் நீங்க சொல்ற நாலேஜ் அண்ட் விஸ்டம். வேரஸ் அந்த அவங்க ஸ்டோர் பண்ணியிருக்கிற சாஃப்ட்வேர்ல அப்படியே இருந்தது பாருங்க, இந்த பக்கம் 6 இருக்கு, இந்த பக்கம் 10 இருக்கு. இவர் 10 into 6 வந்து டெடியூஸ் பண்ணி ஒரு ரிசல்ட் கொண்டு வரது இஸ் த நாலேஜ் அண்ட் த விஸ்டம். தீஸ் 6 and 10 ஆர் தி டேட்டா. அப்போ அந்த டேட்டாவை எதுல சோர்ஸ் பண்றாங்களோ அதுதான் சோர்ஸ். இஸ் அ வெரி குட் கொஸ்டின். நீங்க ஆக்சுவலா அந்த ஜட்ஜ்மெண்ட் சென்னை மெட்ரோ ரயில் ஐ எம் நாட் ரெடிலி ஹேவிங் சென்னை மெட்ரோ ரயில் நானும் டிவிஷன் பெஞ்ச் ஜட்ஜ்மெண்ட் ஒன்லி வெரி ரீசென்ட்லி இந்த லேட்டஸ்ட் லூஸ் பார்ட்ஸ்ல இருக்கும். ஸோ அதுல வி ஹவ் டெல்ட் வித். அப்போ சுய அறிவு ஸ்வ புத்தியில அவங்களோட புத்தியும் அதை நான் தமிழ்லேயே சொல்லியிருப்பேன். தன் அறிவை யூஸ் பண்ணி நம்மளோட அறிவை யூஸ் பண்ணி அதை அனலைஸ் பண்ணி அதுலேருந்து வர அவுட்புட் வந்து இட்ஸ் நாட் அ டாக்குமெண்ட். It is to that extent is the knowledge and the wisdom. That's your correct question only. Therefore, knowledge and the wisdom is different. Actual data and the source is different. So, this is the small explanation which I could give. I think உங்களுக்கு புரிஞ்சுதா? Okay. Very good. Therefore, generally, offense committed by individuals and offense committed by the companies, நம்ம என்ன சொல்றோம்? General law பத்தி சொல்றேன். Then I will come to the Information Technology Act. Therefore, if an offense is committed by, we'll first வந்து IPC scenario மட்டும் பார்க்கணும். புரியுதுங்களா? IPC scenario மட்டும் பார்க்கும்பொழுது, if a person commits an offense, is an individual. அப்போ அவருக்கு நம்ம தண்டனை ஈஸியா அவரை சம்மன் பண்ணிடுறோம், அவர் தண்டனை வழங்குறோம். அப்போ if the offense is committed by a company, now the provision in the CRPC is that the company can nominate a person. The company can nominate a person who will undergo the imprisonment if any. நாளைக்கு கோர்ட் ஆர்டர் வந்து imprisonment பண்ணாங்கன்னா அவர் தான் அந்த பனிஷ்மெண்ட்டை undergo பண்ணுவார். That is in the IPC scenario. That is why நீங்க எந்த ஸ்பெஷல் ஆக்ட் உங்களுக்கு கொண்டு வந்தாலும், ஃபார் எக்ஸாம்பிள் நெகோஷியபிள் இன்ஸ்ட்ருமெண்ட்ஸ் ஆக்ட்ல if the offender is a company, it says all the directors are entitled or liable for punishment. ஒரு கம்பெனி அஃபென்ஸ் பண்ணுச்சுன்னா அந்த கம்பெனியோட அஃபேர்ஸ்ல, கண்ட்ரோல் ஆஃப் அஃபேர்ஸ்ல எந்தெந்த டைரக்டர்ஸ் இருக்காங்களோ அவங்க எல்லாருமே they are liable for punishment ன்னு there is a specific provision under the Negotiable Instruments Act. Similar enactmentல there is provision. Therefore, now coming back to the IT Act also has the similar provision. So even under the IT Act, there is a provision under section 85 where a person committing a contravention of any of the provisions of this act by any rule, direction made thereunder is a company. Every person who at the time of contravention was committed was in charge of and was responsible to the for the conduct of the business of the company as well as the company shall be guilty of the contravention, shall be liable to be proceeded against and punished accordingly. This is the enabling provision. For this provision is not there for the IPC offense. For one company வந்து வெறும் IPC offense மட்டுமே பண்ணா என்ன ஆகும்? You will only prosecute that company. Company can nominate any person. அப்ப அதுல ஜெயில் தண்டனை நீங்க கொடுத்தீங்கன்னா அந்த பர்சனுக்கு தான் அது போய் சேரும். So, but that is why all these special enactments which say that if the offender is a company, all the directors or any person in charge can be prosecuted and they will all be punished. You can have a number of special enactments, you can see such provisions. Therefore, IT Act, there is a specific provision under section 85. Yeah. Anything else? Okay. So therefore, general rule, idhula non-abstantee class irko, that will prevail. So that is what in section 65B le enna sonanga. Notwithstanding non-abstantee irundhuna, that will prevail. And secondly, that will depend on the subject. For example, generally வந்து IT Act தான் prevail பண்ணும் அப்படினு நம்ம சொல்ல முடியாது இல்லையா? So what happens is, when you what are the rules, general rules உங்களுக்கு என்ன? When if there are three only rules which they say whenever there is conflict between two enactments. Firstly, a special act will override a general act. இல்லைங்களா? And if there are two special acts இருந்ததுன்னா, the later enactment will provide over a earlier enactment. So these are the general rules in which we apply. So you can't just in any it will depend on the context of that case. இப்போ நம்ம எந்த ரூலை அப்ளை பண்றோம்ன்றது பொறுத்து தான் இருக்கு. Where some other enactment is a special enactment and then the IT Act is becomes a general feature, then that special enactment overall. But when it comes to the electronic record or other maintain பண்றது அதோட security பத்து வந்ததுன்னா the IT Act will prevail. That is the rule which we prevail. Yes. Anything else? Yes, sir. Okay, very good. So now we are into the area of deep learning and the machine learning, where the machine itself can learn and it can do so many things. That is, we call it as artificial intelligence. அப்போ அவரோட question என்னன்னா, இப்போ artificial I created a computer for listening to the master's voice and then executing the work which is performed. நான் எய்ம் பண்ணது என்னன்னா, ரோபோ நீ போய் இந்த ஹாலை ஃபுல்லா க்ளீன் பண்ணு. அப்போ ஈஸியா நம்ம சொல்றோம் இல்லையா, நம்ம எல்லார் வீட்லயும் இருக்கு. இப்போ நவ் கூகுள் இருக்கு, அலெக்சா இருக்கு. அலெக்சா இந்த பாட்டு போடு, அது பாட்டு போடுறதோட நிறுத்திச்சுன்னா பரவாயில்ல. அப்போ அலெக்சா வந்து இப்போ என்னன்னா தானா கத்துக்குது. நான் வந்து அதுக்கப்புறம் வந்து ஐ எம் ஸ்பீக்கிங் சம்திங் எல்ஸ், ஐ எம் பிளானிங் டு கமிட் அன் அஃபென்ஸ். ஸோ இது பெருக்கிறது தொடக்கிறத விட்டுட்டு அந்த ரோபோ வந்து இட் பிக்ஸ் அப் த நைஃப் அண்ட் it attacks somebody. So therefore his question is, then who is responsible? Now for example, if I have the robo myself, then I am responsible. illa நான் வந்து basic order நான் வித்துட்டு train பண்றது is somebody else. I am only a company which is selling the robo. In what manner you train, you only train, because it is an artificial intelligence, it will only train by itself. Therefore he is asking whether the punishment should be imposed on me or the second person or the third person. Honestly, like the offense, when they coin these offenses, responsibility for machine learning, there is nothing expressly provided in the act. Maybe we have to take a call when the case comes only, because in the year 2000 when our act came, our act was already 15 years behind the schedule only. Therefore it will be a very interesting question. இப்போதைக்கு நான் அந்த பதில் தான் சொல்ல முடியும். I don't know the correct answer for your question. As it goes only. No, it's a very important query which he has raised it. அப்போ therefore the person நான் தானே அதை enable பண்ணி விடுறேன். இனிஷியலா நான் வந்து when I write the software, இப்போ இதெல்லாம் கத்துக்கிற அளவுக்கு I have enabled it. That is one thing. Therefore என்ன குறை சொல்றதா, or you allowed it to be trained in a very bad manner. இப்போ உங்களை சொல்றதா இல்ல ரெண்டு பேரையும் சேர்ந்து சொல்றதா இல்ல ரெண்டு பேருமே not responsible மெஷின் பண்ணதுக்கு நம்ம என்ன பண்றதான்றது it's a very it's a debatable topic and question only. Therefore that is where the deep learning and the machine learning poses the new threat. இதெல்லாம் வந்து we have to again have new provisions to deal with these artificial intelligence and the developments which are going to go. Yes. Okay. So far unga car வந்து மெக்கானிக்கலா உங்க கண்ட்ரோல்ல இருந்துச்சு. This car is again very good example. Now tomorrow நீங்க வந்து ஒரு அதனா டெஸ்லா கார் வாங்குறீங்க. ஓகே, டெஸ்லா கார்ல நீங்க என்ன சொல்றீங்க, கோ பார்க் யுவர் செல்ஃப்னு சொல்றீங்க. அது போய் பார்க் ஆயிக்குது. I recently saw also that's working. அதோட known roadsலலாம் these people அப்படியே கார்ல வந்து இறங்கிட்டு they are going home. அது போய் அழகா அது பார்க்கிங் ஸ்லாட்ல போட்டுக்குது. to that extent. And many of the roads in Californiaல அந்த அளவுக்கு அவங்களோட கூகுள் மேப்லாம் நல்லா இதுவா இருக்கு. it is driving also. So அதுக்கு வந்து இப்போ ஒரு மெஷின் போட்டாங்க. சொல்றாங்களா மெஷின் இருக்கு. அப்போ அது வந்து if it's going to learn itself, அது பக்கத்துல ஏதா இருந்தா இடைஞ்சல் இருந்தா நவுந்து போகணும்ன்றதை பார்த்துட்டு ஒன் டே இட் கெட்ஸ் இமோஷனை கத்துக்குது. வர்றான் ஒருத்தனை போய் ஒரு லேசா ஒரு உரசி பார்ப்போம். இப்போ நம்ம பண்றோம்ல, இப்போ ஒரு டீனேஜர் பையன் வந்து வேணும்னே கலடா பண்றான். யாரோ ஒருத்தவங்க நடந்து வராங்க, ஸ்பீடா போய் அப்படி பண்ணிட்டு அப்படி காசிங் அனாயன்ஸ் ஒரு ஈவ் டீசிங் பண்றான். அப்போ அந்த மெஷின் லேர்னிங் நாளைக்கு அதை கத்துக்குதுன்னு வச்சுக்கோங்க. then who is responsible? அதுதான் அவரோட question. That's because these things can learn by itself so many things. but சாதாரண கார் நீங்க சாதாரண இப்போ ஹோண்டா சிட்டி வாங்குனீங்கனாலே நீ 25 கிலோமீட்டருக்கு போற, நாங்க ஒரு மணி சொல்லுது, நீ அப்படி போவாத. இந்த ஒரு சின்ன சாஃப்ட்வேரே தாங்க முடியல. therefore when it comes by way of artificial intelligence, we don't know what will happen. அது வெப்பன் தானே. அவர் சொல்றாரு வெப்பனா கருதி அந்த யார் தயாரிச்சானா அவனை உள்ள போடணுங்கிறார். அவ்வளவுதானே. கத்திக்கு பதில் அது கத்தி நீங்க கையால எடுத்து குத்துறீங்க, அது கையும் சேர்ந்து அதுவே போகுது. இட்ஸ் அ ரிமோட் எக்ஸசைஸ் மாதிரி. நான் உங்களே இருந்து கையை நீட்டு அடிக்கிறது பதில் இங்க ரோபோ அனுப்பிச்சு உங்களை அடிக்க சொல்றேன். correct. Therefore adan kekrar whether the accused is a machine or the person who created it is an accused. இப்போ வேண்டும்னே நான் வந்து 20 ரோபோ கிரியேட் பண்ணி விடுறேன். see militaries they are now using. so what happens, நீங்க வந்து if you want to go across the territory, இந்த வண்டி ஓட்டிட்டு போணும் இல்ல வந்து போய் deploy பண்ணணும், all the satellites and the long range missiles are what, மனிதர்கள் வண்டி ஓடுறதுக்கு பதில் they are carrying the bombs and they are doing it. Therefore you can't say that the missile is only the accused. The person who launched it is the accused. It is a medium. அப்படி ஒரு மீடியம், அந்த மீடியம் வந்து இன்டெலிஜென்ட் மீடியமா இருக்கும்போது தான் பிரச்சனை. அந்த இன்டெலிஜென்ட் மீடியத்தை நானே இதை சொல்லி அனுப்பிச்சுனா பிரச்சனை இல்லை. இட் இஸ் ஈஸி, ஐ எம் தி அக்யூஸ் நீங்க பண்ணிடுவீங்க. அது போற வழியில 2-3 இட் இஸ் பிக்கிங் அப் ஆன் இட்ஸ் ஓன்றது தான் பிரதர் சொல்ற ப்ராப்ளம். எஸ். All right, thank you. I don't want to detain you more than that.
ஒரு அருமையான நிகழ்வு இன்று நடைபெற்றது. இந்த நிகழ்வு வந்து 7வது வாரத்தின் தொடக்கி வைக்கிறதுக்காக நீதியரசர் வந்து வந்ததும் இல்லாமல் நம்மளோட வந்து இவ்வளோ நேரம் இருந்தாங்க. அது பெரிய விஷயம். இப்போ இந்த 7 வாரங்கள் நான் உங்களுக்கு பாடங்கள் தொடர்ச்சியாக நமது சங்கத்தின் சார்பாக கொண்டு போய்கிட்டு இருக்கோம். இந்த நேரத்தில் இன்றைக்கி நீதியரசருக்கு நன்றி சொல்லக்கூடிய கடமை உங்களுக்கு இருக்குது. அதனால் படிக்க வந்த நீங்கள் மிஸ்டர் முருகேசன் சார் வாங்க, இன்றைக்கி ஓட் ஆஃப் தேங்க்ஸ் வந்து நீங்கள் தான் சொல்கிறீங்க. வாங்க.
குட் ஈவினிங் டு ஆல். நம்மளுக்கு வந்து நம்ம லார்ட்ஷிப் வந்து குறைந்த நேரத்தில் நிறைய தகவல்களை ஒரு ஆக்டவே மைனர் ஆக்டை வந்து நல்லா ஈஸியாக எக்ஸ்பிளைன் பண்ணி புரிய வச்சுட்டாங்க. அதனால் அவங்களுக்கு ரொம்ப நன்றி. மற்ற அனைவருக்கும் நன்றி.